of intimate this just doctrine and sort of how these get incorporated fully by then the state of Massachusetts and the state of Maine. But I want to really emphasize this way in which the otherness created and imagined through the doctrine of discovery gets intensely racialized in the 19th century, and that has an ongoing set of legacies through the 20th and 21st centuries, and that there are these still evidences and examples of takings through these same logics that the Christian, the doctrine of discovery was instigated all those many years ago. I know all of you on this call know where all our tribes are in Maine, and just in case you're not sure, this is the residential sort of seat of governments, but then the lands exist across the state. So I want to draw attention to the state of Maine Constitution. The original Constitution identifies Indians in a really particular way in Article 2, Section 1, which has to do with electors. Of course, in 1820, it was every male citizen of the United States of the age of 21 years and upwards, excepting some other people, including women, paupers, persons under guardianship, and Indians not taxed. So this idea that Indians, it's not just Indians, it's Indians not taxed, recognizes some element of Indians living in positions outside of state control. And I think this is a very important piece of it. Today, this part of the Constitution explicitly says every Indian residing on tribal reservations and otherwise qualified shall be an elector, which is great. That's great progress. That was took over 100 years to fix that. But Maine is one of only 5 states to have this Indians not taxed section in the state constitution. There's similar wording in the US Constitution and the 14th Amendment, but it's a very important concept that is rooted in sort of an otherness, that Indians might be outside of this control of the state and have their own elections going on, but also at the same time the state claims them. And it's this both kind of marking this otherness that is a critical part of my argument. So by the time you get through this 1842 decision, Murch versus Tomer, which is a Maine Supreme Court case, you have this otherness reckoned with for the very first time by the Maine Supreme Court in terms of really what that means. And they quickly make this racialized, reinscribe the Christian doctrine of discovery in terms of white supremacy issues and religious supremacy issues, talking about Indians in terms of their imbecility. And sort of how we have this dictate, we the white people, I assume, have these dictates of humanity, and yet so we have our control over them, but they are not fully either separate from us nor fully of us. And so that notion is the perfect place to fill up this otherness, this imbecility, this lesser than. And so the Indians not taxed, identified in the state constitution, quickly becomes racialized. As we move through the 19th and 20th century, in terms of cases and reckonings and Indian agents and this whole complicated history, of which in my 7 minutes I won't say much about, I just want to call attention to the State versus Newell 1892 case, which is a Passamaquoddy hunting case, wherein the Maine Supreme Court talks about the Passamaquoddy is no longer really being a tribe anymore. They can't make war and peace. Although I'm not exactly sure if that's true or not, and sort of saying again, they're not even the same group as the tribe that made the agreement in terms of treaties, recognizing and maintaining fishing and hunting rights through all those years. It's interesting, of course, the court says they're not a tribe, but they keep referring to them as the Passamaquoddy tribe, so it's an interesting contradiction. It's not that hard to find these various contradictions, and it's precisely this. Sorry, this is 4-legged feeding time at my house, so if you hear barking, I apologize. It is this approach, the ignoring of treaties and the way that the federal law governs them, that led to the Passamaquoddy versus Morton case, and then the Maine Indian Claims Settlement Act. I want to just talk slightly, and this just helps set up what Chelsea's going to talk about, but that when we see it this way, settler colonialism is not is seen as a structure, not as a past event. So this is structured, and John set this up perfectly, of all the things that come after in terms of even what we're fighting against as Indigenous people to reclaim lands and our place and attachments to the landscape. And I want to draw people's attention to this great article by Tuck and Yang from 2012 called "Decolonization is Not a Metaphor," and they talk about these 6 moves to settler to innocence that states and settler communities use. And I won't go through all of them. Just the last 2 of them I seem relevant here in terms of what I'm going to talk about, what Chelsea talks about. And the 5th one is forget the past, solve the Indian problem. Let's just all be, now that we all have the land, quote unquote, let's just forget this past and solve the Indian problem, get rid of them. This is done and attempted in Maine and across the US in various ways. And then the reoccupation of the land and redefining, and this is very powerful in the settler state, that, we hear this all the time, the United States is a nation of immigrants, right? That erasure immediately makes everyone have equal access and, erases all these passes in terms of resources, and we all have access to these public resources, et cetera, et cetera. And just one last example of this is, and John mentioned the Maine Indian Claims Settlement Act from 1980, and this is in the case that Chelsea talks about. This is just one of the ways that the state of Maine defines the Settlement Act itself, and it continues this Indians not taxed, you're not quite a tribe, you're not quite here nor there. This sort of mix it as a unique jurisdictional provision that the state has total control unless there's some other things happening and unless Congress does this or does that. And I think that's a really important kind of masking that sort of ongoing in the logics of the doctrine of discovery. So I'll end there, and Chelsea will talk about the recent cases happening related to Penobscot River.
Can you see my slide now? Okay, great. So I hope to ground John and Darren's really great lead-ins with a case analysis. Contemporary case analysis. The legal case analysis that argues that settler logics have been applied in Maine against the Penobscot Nation, specifically mobilized in the 2015 Penobscot Nation versus Frey case. This case provides us an opportunity to identify when and how contemporary settler imaginaries and investments fuel legal interpretations, which then foreclose on Indigenous attachments, meanings, and sovereignties. So as a backdrop to this case, it's important to frame the legal intentions of the Maine Indian Claims Settlement Act, which stated clearly in 1980 that the power of the state of Maine to alter such subsistence rights without the consent of the tribe had ended. However, the Penobscot Nation versus Frey case of 2015 abrogated the Maine Indian Claims Settlement Act by ruling that the 60 to 70 miles of navigable water in the main stem of the Penobscot River were not part of the Penobscot Nation's ancestral territory. So in turn, the Penobscot Nation argued that separating the Penobscot River from the Penobscot Nation violated federal Indian law and equated to a territorial taking. So to identify settler-driven logics actualized through legal determinations, we deconstruct the case on 4 registers. In our analysis, we see these 4 moves as a series of denials by the state, which are galvanized in ongoing state incursions and claims over Penobscot territory through the denial of retained and treaty-recognized sovereignty. This first space is the Penobscot Nation requested for the case to be deliberated under the Indian canon of construction. So under the Indian canon of construction, all ambiguities in treaties and statutes related to Indians must be construed in their favor and as they understood the law or agreement at the time. This request was based on the tribe's argument that ambiguity concerning what defined the Penobscot Indian Reservation existed within the previous Settlement Act of 1980. So the request to deliberate the case under the Indian canon of construction was denied by the court's claim that no unclear language existed in the Settlement Act's use of the phrase, "the islands in the Penobscot River," which meant to demarcate the Penobscot Indian Reservation. So this decisive ruling rested on the simple semantics of islands being in the river versus on the river. And this is a crucial moment in the case, which enabled a snowball effect of other denials by the court that served to weaken the legitimacy of the arguments provided by the Penobscot Nation throughout the case. And if the Indian canon of construction had been applied legally, the court would have been required to afford a place of legal pluralism sophisticated enough to recognize different cultural conceptions of law and territory. So through this, the relational framework of rights and responsibilities towards the Penobscot River, argued by the Penobscot Nation, would have held legal standing and not become vulnerable to territorial enclosures through the simple semantics of in the river versus on the river. So the second point of analysis dovetails into the first. An online Oxford English Dictionary search of the word island was used by the court to designate the Penobscot Indian Reservation as, quote, "a piece of land that is completely surrounded by water." This maneuver legally flattened the presence of Penobscot critical heritage to place while ignoring previous federal statutes which support that even seemingly straightforward text should be informed by the purpose and context of the statute. If applied correctly, this in essence would have elevated the law above the dictionary. So in this instance, settler colonial will applied through the legal adjudication and abrogation of native land rights refused recognition of Penobscot cultural existence and critical heritage, which as a riverine peoples is not limited to land-based enclosures. So thirdly, we argue that environmental legitimacy was racialized in one way seen through the First Circuit Court of Appeals decision written by Judge Lynch in the deterministic and, we argue, paternalistic language you see here. We argue that this pejorative assertion makes legible the invisible asterisk, a proviso which hovers above every enunciation of Indigenous customary law. So if an Indigenous person slip, if they seem to be being opportunistic or speaking to the public or law too much or not enough, they risk losing the few judicial and material resources that the state has made available to them. Judge Lynch concluded that the nation may regulate and restrict access to the island within the river, again reductive semantics, but not activities on the river itself. Penobscot Chief Kirk Francis has explained that access by non-native hunters to the tribe's territorial lands and waters have never been denied, while permits are required to take resources critical to the sustenance-based lifestyle of the tribe. That part. So the third point is closely married to our fourth point of analysis. During the case, the nation further argued that the removal of 60 to 70 miles of navigable waters from the Penobscot Indian Reservation posed a threat to its sustenance fishing rights. In response, Judge Lynch again denied the presence of such a threat. The court claimed that the removal of a regulatory jurisdiction from the tribe did not establish a threat to the Penobscot Nation's livelihood, again denying the Penobscot Nation's critical heritage and relationality to the more than human world. So this singular lens of analysis, we argue, illegally forecloses upon the Penobscot Nation's critical heritage through a narrow settler framing and interpretation of what sustenance fishing entails for riverine peoples, and importantly, what harm entails in this context. In this ruling, the rationale used by the court is incommensurate with Penobscot definitions of place and starkly devalues the Penobscot Nation's legitimation of a threat. What appears as a myopic or narrow, short-sighted ruling is argued here as ongoing strategies in settler courts, which establish an epistemological dominance on which to base rulings. These enactments of dominance suitably ignore Indigenous interpretations of treaties and other agreements, all in violation of the Indian canon of construction. This unidimensional legal space galvanizes the foreclosure of imaginaries and connectivities beyond the settler state, and in this specific case, effectively removed Penobscot ancestral territory, constituting a territorial taking. So I'll stop there and leave you with these final thoughts from Penobscot citizens. Thank you.
Thanks, Chelsea. That was really good. Actually, it makes me, to hear you say it, it really makes me excited. So I really appreciate your work on it.